My first question is, let's say a client comes in and says he or she wants a divorce. What's the first question we should ask them?
Okay, so particularly since we are the Christian Legal Clinics of Philadelphia, we understand that divorce is not a good thing. Sometimes it's a necessary thing. I think you want to establish that a divorce is actually necessary. So what I would often ask people that say they want to get a divorce is, have they discussed it with other folks besides an attorney, right? So you want to, if they're in a church, it's something that they should certainly talk to, their pastor about. Or if they have a counselor or a therapist, it's something that they want to talk to their counselor or therapist about. Or if they have friends or family that they trust, it's something that they should talk to them about. I mean, I would not recommend anybody getting a divorce if the first person they've spoken about the divorce with is an attorney. So I'd at least establish that this is something that they've gotten other counsel about aside from just an attorney. So
yeah, that's great.
I can't actually see. So I have this thing. Oh, that's actually asking me if I consent to be. I thought that was just something on the other screen. Okay.
Okay. My next question is, sticking with the scenario of a client wanting a divorce, what difference does it make whether the other spouse is in agreement?
So if the one spouse if both spouses want to get a divorce, then you can get a divorce, right? So there's a consent divorce in Pennsylvania, and essentially all you have to do is both parties need to consent to a divorce 90 days after the initial divorce complaint is served. Okay. And it becomes even easier if the parties have been separated for more than 1 year. Then they don't have to wait that 90-day period. So if both parties want a divorce, then you can get a divorce. But if one spouse does not want a divorce, it can be a little bit more difficult, but you can still get the divorce because all you have to do is be separated for over a year. If it's a simple divorce and both parties agree to the divorce and there is no property to be divided, no issues with custody or spousal support, then what I usually recommend is filing in Cameron County or Potter County, because the filing fees are about $250 less than they are, or $300 less than they are in Philadelphia, and it's a quicker process. So you often see Cameron County and Potter County divorces, but that only works if both parties agree. And both parties, not only do they agree, but they're willing to sign their name to it. Like, so if one party is just agrees, but isn't willing to do the work to sign his or her name to it, then a Cameron or Potter County divorce won't work. But if both parties agree and are willing to sign their names to the divorce, and there's no property to be divided, no custody at issue, and no spousal support at issue, then I would recommend filing in Cameron or Potter County. But if there are outstanding issues regarding property, support, custody, or if one party does not agree, then you have to file in Philadelphia or the county in which one of the parties resides. Yes.
Okay, thank you.
And the reason for that is, it's if you file in a county outside of Cameron or Potter County, if you file Cameron or Potter County, then the objecting spouse, or the spouse that's going to bring up any claims, is going to file to have it removed from Cameron and Potter and moved into Philadelphia. So
Great, thank you. And what are the different grounds for divorce?
So before no fault divorce, the grounds for divorce, I mean, I don't even know them offhand because they're never used. So like obviously adultery, abandonment are grounds for divorce, but nobody ever uses that actually anymore. I mean, I'm sure some people do, but it's very rare. So essentially, if you want to get a divorce, you have to prove that you've been separated. Well, okay, I see this now. So the fault divorces are adultery, desertion, barbarous treatment, bigamy, imprisonment for crime. I'm not able to see the entire PowerPoint. But again, like I said, the at-fault divorce rarely used, because if there is a no-fault divorce, then all that the party that wants the divorce has to prove is that they've been separated for 1 year. It used to be 2 years, but the PA legislature amended that, and it's down to 1 year. So as long as the parties have been separated for a period of at least 1 year, then there are grounds for divorce. So that's, or if both parties agree, then there's also a grounds for divorce. So you generally speaking, you establish divorce by both parties consenting, or a 1 year a 1 year separation period. And again, if both parties consent, there's a 90-day waiting period after service of the complaint and before the consents can be signed.
Great, thank you. And what if someone comes in who has been served with a divorce? What are the top things you need to know in that situation?
Sure. So if somebody's served with a divorce, well, then you would want to ask them, do they want to get a divorce? All right. So, and if they say they don't want to get a divorce, well, then there are ways that you can delay a divorce, but you can't stop a divorce from happening. If they do want to get a divorce, then the issues, and even if they don't want to get a divorce, whether they want to get a divorce or not, the issues generally are whether they have any property rights or whether there are kids involved. So you would, if somebody is served with a divorce complaint, you say, well, have you, what kind of property have you acquired with your spouse during your marriage? Because what happens is a marital estate is essentially formed. It becomes kind of like a legal entity. It's not, but it's kind of like that. A marital estate has been formed, and the marital estate is essentially property that was acquired after the date of marriage and before the date of separation. So property that either party or both parties acquired after the date of marriage, before the date of separation, becomes property of the marital estate. And that is what the divorce judge or the divorce master is going to divide before divorce. And it has to be divided before divorce if a claim for property division or equitable distribution has been made. If a claim for property division has been made by either party, then there can be no divorce until that claim has been satisfied or decided upon by a divorce court. As it says here, there's no default for divorce. If you have a client that's been served with a divorce complaint, I think what you basically have to establish is whether they are the economically disadvantaged or the economically advantaged spouse in the marriage. Generally speaking, you'll get, usually if for instance the husband works and the wife stays home, then you have to be very aware, and the wife comes to you, then you have to make sure that she is knows that she has a right to make claims for support, for property division, and for alimony. Obviously, if the wife works and the husband does not work, and the husband comes to you after being served with a divorce complaint, then you'd have to make sure that the husband understands the disadvantaged spouse, the economically disadvantaged spouse, needs to understand that they can make claims for the property of the other spouse. If one spouse makes more than the other, then the spouse that makes less can file for spousal support, alimony, or alimony pendente lite. It's kind of one and the same for the purposes of this conversation. That's monthly payments, support payments from one spouse to the other. Oftentimes, custody is not filed with a divorce, but if the parties have minor children, then custody is going to most likely become an issue. So you have to raise that issue with the parties as well. If a custody count was not included with the divorce, then you have to understand if the party wants a court-ordered custody arrangement. If your client is served with the divorce papers, you need to know if they are the economically advantaged or disadvantaged spouse. If they're disadvantaged, then you want to make claims. If they are the advantaged spouse, then it would be the job of the other party to make the economic claims.
Great, thank you. Okay, let's talk about other information you need in any divorce case. What else should we be asking?
Sure, yeah, so in a divorce, you want to find out if there are any children involved, okay? So you ask how old the children are and who do they live with. If the parties are separated, then you want to get an idea of who the children are living with, because who the children are living with is important even if there's not a custody order, because if the children are with one of the parties, they're kind of establishing a sense of normalcy with that party, and a custody/divorce judge down the line is going to be less likely to overturn that sense of normalcy that they have established. Obviously, it's important how old the children are, because if the children are 16, 17, 14, 15, then, a custody order, maybe is something that you might not want to consider, because the kids are just going to go wherever they want to anyway. If the kids are older than 18, then obviously you're not filing for custody for the kids that are older than that. But yeah, you want to get an understanding of where the children are, how old they are, because with a divorce comes issues of custody and also child support. Yeah. Then you want to get an idea of the income of both of the spouses. So if your client or your potential client has more income, then it's likely that they will have to pay spousal support if the other party makes a claim on it for spousal support. If your client has less income, then you want to make them aware that they have the right to make a claim for spousal support. So you need to know what the income of both parties are. Not only do you need to know the income, but you want to know the assets. And generally, the number one asset is real estate or a house. And if there's more than just the marital home, then you want to know what other real estate the parties own. Obviously, cars, bank accounts, stocks, retirements, and inheritances, also important. Generally, the two biggest things that get litigated and split up, in my experience, in property division divorce cases, is real estate and pension plans, or some sort of employer-provided retirement plan. So again, you have to establish what property in the meeting, in your initial meeting with your potential client, you want to establish what property either or both of the parties owned at the date of their marriage, and also then what properties either or both of the parties owned at the date of separation, because the property that was acquired between those dates is the property that basically is part of the marital estate, and that's what's going to be divided. If property was acquired after the date of separation, then that's not property that's going to be part of the marital estate. It's still relevant to how the marital estate is divided, because, you know, maybe if, for instance, if a party acquired a bunch of property since the date of separation, then a divorce judge might give that party a little less of the split of the marital estate. So, you know, the marital estate is usually split 50-50, 60-40, 70-30, depending on how advantaged one party is to the other. And one more thing. So if real estate was acquired before the marriage by one of the parties, or any kind of property, if that property increases in value during the marriage, then the value of the increase of the property is subject to division. So
Great, thank you.
Yeah.
And we always hear that in divorce, things get split 50-50. Can you explain a little how property division and alimony actually works?
Sure. So let me see what this. Sure. So can you repeat your question, Kelly? Sorry. What was the question again? Kelly, can you repeat the question? Sorry.
Sure, no problem. We always hear that in divorce, things get split 50-50. Can you explain a little how property division and alimony actually works?
Sure. So again, property division, again, it's a marital estate, property acquired after date of marriage, before date of separation. It's divided between the two parties, all right? But it's often not divided 50-50. So if the economically advantaged spouse, the spouse that has more income, more money, is most likely going to get maybe 30 or 40%, and the economically disadvantaged spouse would maybe get 60 or 70%. If there's a clear, so you have to keep that in mind when counseling a client, or as well as when you are negotiating a settlement with the other party. Also, with alimony, my experience with the spousal support, generally speaking, a court will look at the income of one party, look at the income of the other party, and 40% of the difference is usually what the economically advantaged spouse will owe to the economically disadvantaged spouse. So if you have one party making, you know, $1,000 a month and another party making $2,000 a month, the difference is $1,000. 40% of that is $400. So the payment from the disadvantaged spouse to the advantaged spouse would usually be in the ballpark of $400 or so per month. That would be spousal support, and that would also is something that would also become alimony. In my experience, courts usually allow alimony to run for about 1/3 of the amount of time of the marriage. So if the marriage from the date of marriage to the date of separation is 20 years, let's say, and there's a divorce after 20 years, then 1/3 of 20 is 6, or six and some change. So so there would probably be ordered alimony, a period of alimony for about 6 years. And again, that would be, you know, 40% of the difference between the two party's income. That's rough, you know, and I don't think that's something that they're always going to hold themselves to. That's generally my baseline when you're counseling a party or, you know, entering negotiations with another party.
Does the court take pendente light support into account with alimony if they've been going through a divorce process for a year and a half now and they've been getting?
Yeah, sure.
Are they
Yeah.
going to shave off time?
Yes, that's a good question. So I think so. I mean, in my experience, like, yes. So if you are receiving alimony pendente lite or before the date of the, so the difference between alimony pendente lite and alimony is one is before divorce and the other is after it. Spousal support is also before divorce. The difference between spousal support and alimony pendente lite are, I'd say, not terribly important for this conversation, but they're very similar. And so, yeah, if you've been separated for 2 years, and for those 2 years you've been receiving either spousal support or alimony pendente lite, I would say yes, that will shave 2 years off of the time period that you receive alimony post-divorce. But again, this is often negotiable, and you know, the way it's set up in Philadelphia, you're going to go in front of the divorce master, and the divorce master doesn't enter an order. It's basically he just enforces, he recommends an order, and the parties then come to an agreement based on the order that he recommends. And like 95% of the cases in Philadelphia settle that way. So you're just basically, you need to have an understanding of, you know, what you can expect. And again, a baseline expectation is 1/3 of the length of marriage is the time period of alimony pendente lite plus alimony, or spousal support plus alimony. So whether it's one is more than the other doesn't really matter, I guess.
Right. As far as when clients come in and there's been an alleged affair, I know it doesn't really play into account whatsoever with the divorce, but it can affect equitable distribution. How exactly does an affair or extramarital affair come into play with that?
Okay, well, so when a client comes in alleging an affair, if they have good evidence of it, I feel better about, you know, being a divorce attorney when the other party is doing something like that. But they will also, they will also think, yeah, because my spouse is at fault in the termination of this marriage or the ending of this marriage, then I'm going to be awarded with more property in the property division. But that's not necessarily the case. So like there's custody factors in custody. There's a similar list of factors in the law regarding the equitable distribution of marital property. And none of the factors have anything to do with, you know, who's at fault in the breakup of the marriage. So that's actually not terribly relevant. Like who's at fault in the breakup of the marriage, who's cheating on whom, that's not terribly important when it comes to property division. I mean, the issues that are important when it comes to the property division are issues that are generally just related with money. Who makes money, who doesn't, who's able to make money, who's not able to make money, who blew money during the marriage, who didn't blow money during the marriage, things like that. But who's cheating on whom? An equitable distribution judge or master is not going to want to hear any evidence on that, generally speaking. But your client coming in is going to think that, you know, they're going to get more money because they're not at fault, but it's not actually the way it goes in my experience. And
Right.
Is she doing that?
Oh, I guess she's.
Thank you so much, Phil and Kelly, for that presentation. That'll help our volunteers out so much who don't touch family law and don't do divorces. That'll give us just a good understanding of of what information you want us to grab before we ask you to before we ask you to look at the case. Thank you so much.
Thanks, Heather. Thank you.
Thank you.